Human Rights Bill for Scotland appears to be trying to entrench into law duties of compliance with things that are really not human rights at all, things like sustainable food or a healthy environment, but which are being reframed as human rights in order to give them the same kind of ethical standing as core human rights, like the right to life or the right not to be tortured. I don't know whether similar human rights bills are being introduced in other countries or maybe have been introduced already. I would imagine this is the case because this Scottish bill appears to be loosely based on UN's Agenda 2030. And I say loosely based because it appears to conflate core human rights with the UN's economic, social and cultural rights. This is all starting to sound a little bit complicated, and I personally think that might be intentional because it's all meant to go over the heads of us little people. And I'll go back to that later when I go through the easy read version of this consultation. But I think it's very important to drill down into what's really being said in this consultation, because otherwise it can just sound like something nice and fluffy. So these economic, social and cultural rights include the rights to adequate food, to adequate housing, to education, to health, to social security, to take part in cultural life, to water and sanitation, and to work. In this economic, social and cultural rights category, the UN has introduced the concept of progressive realisation, which means that member states are required to progressively achieve these rights over a period of time. And as part of the progressive realisation, the concept of minimum core obligations has been introduced. This is a kind of benchmark level that member states are required to achieve under various rights categories. The introduction to the Human Rights Bill consultation paper actually includes a case study in section 7. It starts off sounding very innocuous, as these things often do. Minimum Core Obligations Case Study, the right to the highest attainable standard of physical and mental health. General Comment 14 of the committee sets out guidance as to what should be considered within the minimum core obligations of this right. Broadly speaking, this includes, at the very least, access to and equitable distribution of health facilities, goods and services without discrimination, especially for those vulnerable and marginalised. Minimum essential and nutritionally adequate food to ensure freedom from hunger for all. Basic shelter, housing and sanitation, and adequate water. Essential drugs. Essential drugs? What kind of drugs are they referring to here? A national public health strategy and action plan based on evidence. In addition, the guidance says states or member states should also prioritise providing reproductive, maternal, prenatal as well as postnatal and child health care, which all sounds great. Immunisation against major infectious diseases. That could be interpreted in a number of different ways. Is it something that the state must give you as a right? And would you have the option to refuse? Prevention and control of epidemic and endemic diseases. But it doesn't say what kind of measures would be used and who would decide what constitutes an epidemic or an endemic disease. After all, we've seen the World Health Organization's definition of epidemic disease change significantly in recent years. Education and access to information on health issues, including on prevention and control. I'm wondering if this education and information is based on science or on the science. Training for health personnel, including education on health and human rights. Part 4 of the consultation paper outlines a kind of duties and compliance that are being entrenched under this bill, and it uses a lot of acronyms and arcane terminology like duty bearers, which are quite jargonistic to modern human rights work and are not easily interpreted or understood. This document explains the concept of duty bearers. It says, the state is the main duty bearer when it comes to defending human rights, and other duty bearers are people who are employed by the state, including Scottish ministers, Scottish government officials, local authority staff, teachers, social workers, health workers such as doctors and nurses, and police officers. In part 4 of the introduction to the consultation, it says, "We are considering recognising and including the right to a healthy environment in the bill for core economic, social and cultural rights and the right to a healthy environment. Putting an initial procedural duty on public bodies and, so far as possible, private actors." And note that it doesn't specify who these private actors might be. Presumably they're meaning business, but it could also mean farmers, or it could mean you and me. It could mean anyone who's contracted by the public service. Delivering devolved public functions to build the rights into the fabric of their decision making. This would apply for a period of time following the bill passing to give duty bearers time to prepare for a subsequent compliance duty. Moving to a duty to comply with the rights for public bodies and, so far as possible, private actors delivering devolved public functions. The duty to comply will be demonstrated by progressively realising the rights and ensuring the delivery of minimum core obligations. And it continues. For the first time in our domestic legal framework, duty bearers will have to actively consider the rights in ICERD, which is the International Convention on the Elimination of All Forms of Racial Discrimination, CEDAW, which is a Convention on the Elimination of All Forms of Discrimination Against Women, and CRPD, which is a Convention on the Rights of Persons with Disabilities when delivering services such as housing, social care or social security, and can be held accountable if they do not. So again, it all sounds nice and fluffy, but what exactly does it mean? How is it going to be interpreted? Could it mean, for example, that house builders and landlords could be held accountable if they don't provide lifts suitable for disabled people? While accessibility is an important and it's a desirable consideration, obviously, such laws could potentially be used to preserve corporate monopolies and restrict business competitiveness to big players. I do think these considerations are really important, but I don't think that they have a place in a human rights bill. Human rights should be about freedom of religion, freedom from persecution, and it shouldn't be about being forced to comply with vague ideals that could be interpreted in many different ways. These issues should be dealt with in a different part of the legal framework. With all these arcane, jargonistic terms, it could seem tempting to respond to the easy read version of this consultation rather than trawling through the long version. But I would advise against this. And I'll run through the easy read version at the end of this video so that you can see why. This is why I'm presenting my answers here. Do feel free to copy them if you like. Or alternatively, they might just make you think about what this bill really means, or really could mean for all of us. So, after all this discussion, the first question is, what are your views on our proposal? What are your views on our proposal to allow for dignity to be considered by courts in interpreting the rights in the bill? And it has a yes/no answer, allow or don't allow. Almost as if you're saying, no, I don't think human dignity is important. So manipulative. So my response was don't allow. And I added in the text box, this distorts the concept of human rights, as well as only being vaguely related to the preamble above. Human dignity is a value and an ideal, a concept that is desirable, spelling mistake, a concept that is desirable to uphold at all times, but which is widely open to interpretation. If an elderly person has to be taken to the toilet by a professional carer, is that a violation of their human dignity? Putting human dignity at the heart of a human rights bill could leave it open to political manipulation. Question 2. What are your views on our proposal to allow for dignity to be a key threshold for defining the content of minimum core obligations? My response, don't allow. And I expanded in the text box. Minimum core obligations should have no place in a human rights bill because, by their very nature, human rights are inviolable. No interpretation should be required of the right to life, the right to freely practice the religion of your choice, or the right to free speech. If interpretation is required, then it is not a human right. It may be a civil right or a value or an ideal that may be desirable to enforce in law. For example, driving while sober is not a human right, but it is important to everyone's safety to enforce it by law. Human rights should hold governments to account, not the other way round. Question 3. What are your views on the types of international law, materials and mechanisms to be included within the proposed interpretative provision? If so, please identify these. Explain why and how this could be achieved. My response: this bill has a top-down feel to it, as the framework has been generated by the UN. The UN was established after the Second World War with a view to cooperation and communication between nations, which would hopefully prevent future wars. Human rights was integral to this process because it was important to establish international boundaries that would not allow any nation to inflict the atrocities that the Nazis had perpetrated ever again. Unfortunately, having read the documentation related to this, I feel that the UN is acting out with its remit. There is too much detail and too much that is vague and open to interpretation and thereby manipulation. I don't understand why the European Convention on Human Rights has to be replaced. The whole exercise feels very undemocratic. Also, the question doesn't make sense grammatically. Question 4. What are your views on the proposed model of incorporation? We are seeking to incorporate the 4 international treaties into Scots law and recognise and include the right to a healthy environment within the limits of devolved competence, making them binding and justiciable to the extent we are able. Our overarching aim in considering how we structure the bill and the way we give effect. My response: this is simply wrong in my view. The right to a healthy environment is not a human right. It is too vague and too open to interpretation and thereby manipulation to be considered as a right. It is a value, an important one. But to tag it onto the core human right that all people are equal is, in my opinion, dangerous political manipulation, especially as this is to be made binding and justiciable. As I've said, a healthy environment is not just desirable but important. But who defines the detail of this? Would it lead to a ban on the spraying of silver iodide and other chemicals into the atmosphere? Or could it be used to ban certain types of cars? Or to enforce the wearing of face masks or other practices that could violate bodily integrity? There are many serious questions around this issue, and to tag it on to core essential human rights seems politically manipulative. Question 5. Are there any rights in the equality treaties which you think should be treated differently? My response: yes. I don't understand the necessity for incorporating international treaties related to human rights. This should not be happening. Human rights are about holding governments to account in order to prevent abuses of power and atrocities such as torture or genocide. Human rights should be clear enough for everyone to understand. If more complex issues are tagged on to human rights, this can potentially turn human rights into a lever of control that could be used negatively by people in power. This is an approach that can induce feelings of mistrust and of being hoodwinked. Question 6. Do you agree or disagree with our proposed basis for defining the environment? We want to recognise and include the right to a healthy environment in the bill. This will help to ensure a healthy and sustainable environment in Scotland and provide a platform to tackle issues related to environment and human rights so that they are realised together. How we approach defining the right will be a key part of ensuring it is an effective and transformative. My response: disagree. Question 7. If you disagree, please explain why. A healthy environment is an important value, but it is too vague and open to interpretation to be seen as a human right. Linking human rights with the environment distorts the principle of human rights, potentially turning it into a lever of control. Human rights should hold power to account, not provide power with increased means of control. The sentence above, this will help to ensure a healthy and sustainable environment in Scotland and provide a platform to tackle issues related to the environment and human rights so that they are realised together, is quite astonishing. Human rights should be recognised, not realised. The right to life, freedom from slavery, freedom to practice the religion of your choice are not ideals to be realised, but inalienable, inviolable rights. Question 8. What are your views on the proposed formulation of the substantive and procedural aspects of the right to a healthy environment? The right to a healthy environment is yet to be enshrined within an international treaty. Despite this, more than 100 countries. My response. The fact that substantive aspects have to be listed and awareness raising and education carried out shows that a healthy environment is not a human right, but a value set that is widely open to interpretation. Just because 100 other countries have enacted legislation that twists the meaning of human rights does not mean that we should follow suit. Question 9. Do you agree or disagree with our proposed approach to the protection of healthy and sustainable food as part of the incorporation of the right to adequate food in International Covenant on Economic, Social and Cultural Rights, rather than inclusion as a substantive aspect of the right to a healthy environment? After engaging with stakeholders, we are also reflecting on whether healthy and sustainable food should be understood as a substantive aspect. I think this bit is particularly devious, given that human rights are indivisible, interrelated and interdependent and should not be viewed in isolation of one another. Incorporation of the right to adequate food should provide adequate protection for the environmental aspects of food production. My response. Both of these options are wrong. Access to food can be seen as a human right, but attaching the words healthy and sustainable turn it into a value, as these descriptions are widely open to interpretation and easily open to manipulation. Aiming to improve the nutritional value and material sustainability of food can be desirable, depending on the methods used, but incorporating it into a human right turns that right into a tool of control. And as I've stated earlier, a healthy environment is not a human right, but a value. Question 10. Do you agree or disagree with our proposed approach to including safe and sufficient water as a substantive aspect of the right to a healthy environment? In relation to safe and sufficient water, while this is also understood as a social right, my response. The right to safe and sufficient drinking water can be seen as a human right. Sufficient water essential for the health of the wider environment is not a human right, as it is widely open to interpretation and manipulation. And as I've said in previous comments, a healthy environment is a value, not a right. Question 11. Are there any other substantive or procedural elements you think should be understood as aspects of the right? And my response was no. Question 12. Given that the Human Rights Act 1998 is protected from modification under the Scotland Act 1998, how do you think we can best signal that the Human Rights Act and civil and political rights form a core pillar of human rights law in Scotland? Civil and political rights. We have considered whether the bill could restate the rights in the Human Rights Act 1998 so that all rights are in one place. We understand that the recommendation for a restatement of the Human Rights Act 1998 rights was driven by the desire to have all rights set out together in one place in an accessible way. And it continues, We are concerned that attempting to restate the rights protected by the Human Rights Act 1998 could be seen to have an effect on those rights and could place the bill at risk of challenge on legislative competence grounds, with limited benefits in relation to clarity, accessibility and the enjoyments of the rights. We do not want to risk this bill not coming into force, thus preventing change to improve people's lives. However, we recognise the importance of recognising rights as indivisible, interrelated and interdependent, and we will consider further with stakeholders how we can best do so within current constraints. My response: I don't think that the Human Rights Act 1998 should be restated or modified in this bill. I don't understand who recommended a restatement of the Human Rights Act 1998 or why whoever this was thought it was necessary to have all rights in one place. But there are very good reasons why all the different types of rights should not be in one place. For example, if the right to a healthy environment is placed on the same level as the right to religious freedom, using a wood-burning stove could potentially carry the same legal stigma as physically attacking someone for their religion. In my opinion, this bill should be challenged on the grounds of legislative competence. Question 13. How can we best embed participation in the framework of the bill? I found this a confusing question, and I said that I would come back to it once I'd read part 9. Unfortunately, I forgot. Question 14. What are your views on the proposed approach to including an equality provision to ensure everyone is able to access rights in the bill? Equality provision within the bill. The success of the bill depends on the rights being incorporated in a way which means their protection can be enjoyed and accessed by everyone equally, regardless of status. To ensure everyone can access the rights under the bill without discrimination, we want to include an equality provision. My response: this equality provision should simply not be relevant if rights are indivisible, interrelated and interdependent. The right to life or the right to religious freedom does not hold different weight according to a person's colour or physical ability. And if this is disregarded, there is an existing legal framework for addressing the injustice. My concern is that by adding a provision to ensure everyone can access the rights under the bill without discrimination, the actual effect would be to tag the demand for a healthy environment, which is widely open to interpretation, onto the core human right of equality. Question 15. How do you think we should define the groups to be protected by the equality provision? Equality provision in the bill. The above approach would rely on LGBTI and older age being protected through the use of other status. However, we are also considering whether we should specifically list LGBTI and older age as grounds for protection, given the task force noted that these groups lacked the pretension of an international treaty and recommended explicit protection of them in the bill. Putting these groups specifically on the face of the bill could help ensure clarity of exactly who the provision is intended to protect. My response: the fact that the various protected groups have to be defined raises more questions as to the real aim or effect of this bill. As a person of mixed race, I believe it is of crucial importance to have recourse to the law if my rights are being infringed through discrimination. But explicitly tying ICESCR rights, economic, social and cultural rights, and the right to a healthy environment to protected groups does make me question what this is really about. Is this being seen as a way to encourage protected groups to demand their rights to a healthy environment or to social security and other ICESCR rights? It feels manipulative. If the aim is really to help protected groups, there should be more help for them to access justice when their core human rights are infringed. And this should also apply to people suffering economic hardship, whatever their race or religion. Question 16. Do you agree or disagree that the use of other status in the equality provision would sufficiently protect the rights of LGBTI and older people? My response was disagree. Question 17. If you disagree, please provide comments to support your answer. My response. Dividing people into groups in this way implies that human rights have more importance for certain types of people than for others. Protection of people with protected characteristics should be upheld through the legal system based on their core human rights, which apply to all of us, not to some groups more than others. Question 18. Do you think that the bill framework needs to do anything additionally for LGBTI or older people? My response? No. In response to the later addition of a text box to question 18, I wrote, my response to question 18 was no, and I would like to add the following in the text box. As I wrote in my response to question 17, dividing people into groups in this way implies that human rights have more importance for certain types of people than for others. Protecting people with protected characteristics should be upheld through the legal system based on their core human rights, which apply to all of us equally, not to some groups more than others. Question 19. What is your view on who the duties in the bill should apply to? Our view is that the duties should apply, so far as possible, to bodies carrying out devolved public functions. We will carefully consider the outcome of the UNCRC, UN Convention on the Rights of the Child Bill, reconsideration in developing our thinking in this area, and will carry out further engagement. My response. This section just twists further the concept of human rights, in my opinion. It is so vague that it could apply to almost anyone, and if implemented, it could reframe the idea of human rights to make them a lever of control rather than holding power to account. For example, if bodies carrying out function of a public nature applies to farmers and food producers, this bill could potentially have the effect of putting meat and dairy producers out of business if they are perceived as harmful to the environment, and entrenching the rights of large multinational corporations that have the financial clout to adapt to the demands that the bill might enforce. I say this as someone who stopped eating meat in 1984, and I have a digestive intolerance to cow's milk, so it doesn't come from a personal bias. I think there would be many other examples where this proposed bill could have the effect of entrenching big corporate interests at the expense of small and medium businesses and restricting market choice. Question 20. What is your view on the proposed initial procedural duty intended to embed rights in decision making? We want to place an initial procedural duty on duty bearers as soon as practicable after the bill becomes an act. This duty would focus on ensuring that the rights in the bill are taken into account by duty bearers, built into the fabric of their decision-making processes, and adequately taken into account in the delivery of services. This could apply to policy or programme development, new legislation, as well as budgetary processes and decision-making. This approach aims to strike a balance between delivering increased protection to rights holders and giving duty bearers the necessary time to prepare for the stronger duties outlined below. My response. Again, this is incredibly vague, but could potentially have enormous, wide-ranging effects. I suspect that it could potentially be a massive lever of control. Question 21. What is your view on the proposed duty to comply? Duty to comply, and note that it's identical with question 20. I don't know if that's a mistake or deliberate, so I won't read it again. My response. This clearly alters the principle of human rights from being about holding power to account into being a lever of control. Such a procedural duty should have no place in a democracy. Question 22. Do you think certain public authorities should be required to report on what actions they are planning to take and what actions they have taken to meet the duties set out in the bill? Reporting The above duties would require a reporting duty for duty bearers to be able to demonstrate the action they are taking and intend to take to ensure the rights in the bill are being advanced and built into decision making. We are considering, in relation to that duty, whether to follow the approach. My response: this looks like a way of putting pressure on public bodies and thereby on people to enforce goodness knows what under the remit of the right to a healthy environment. It's a manipulation, a twisting of the concept of human rights. Question 23. How could the proposed duty to report best align with existing reporting obligations on public authorities? Progressive realisation of economic, social and cultural rights and the right to a healthy environment. In international law, economic, social and cultural rights are broadly understood as requiring both that a basic minimum threshold is met and that the rights are to be progressively realised over time using maximum available resources. So this is the compliance aspect. This is based on the understanding that rights such as the right to health and the right to adequate standard of living can be continuously improved over time and in line with a country's resources. This does not mean progressive realisation allows states to avoid their duties. Rather, it is an expectation upon states to move as quickly and as effectively as possible to ensure the full realisation of these rights. The concept of progressive realisation is drawn from Article 2(1) of the ICESCR, which states, my response: this basic minimum threshold and progressive realisation should be a guideline only. If it is enforced in any way, it represents the end of democracy, as it emanates from an outside body acting as a governmental power. Even if it had originated from the Scottish Government, the compliance aspects in connection with the proposed right to a healthy environment and the economic, social and cultural rights, which are widely open to interpretation, are very concerning, have the potential to be used as a lever of control and should have no place in a democracy. What are your views on the need to demonstrate compliance with economic, social and cultural rights, as well as the right to a healthy environment, via minimum core obligations and progressive realisation? Minimum core obligations for economic, social and cultural rights and the right to a healthy environment. As referenced above, in international law, economic, social and cultural rights are broadly understood as requiring minimum core obligations to be met. These are understood to be basic minimum standard of delivering economic, social and cultural rights, and they set a minimum threshold which must always be upheld by a country irrespective of resources. In international law, the minimum core of a right must be complied with immediately unless it is demonstrably impossible for the state to do so. It is therefore a minimum floor from which the progressive realisation of the right builds on. Our intention is that the duty to comply with economic, social and cultural rights. By response, establishing minimum core obligations for rights that are so widely open to interpretation as the ones referred to represents a massive lever of control and would be a major step towards turnkey totalitarianism. Human rights are inviolable and inalienable. Their objective is to hold power to account, to place boundaries on power. They are to be observed, not worked towards. As I've said before, this kind of enforcement has no place within a democracy. 25. What are your views on the right to a healthy environment falling under the same duties as economic, social and cultural rights? My response: neither of these categories should be included in a human rights bill, as they are not human rights. 26. What is your view on the proposed duty to publish a human rights scheme? My response: this appears to be a plan to publish what is being done in the name of human rights. The use of the word scheme seems significant, as the whole thing looks like an exercise in manipulation and stealth, as some of the categories are so vague and open to interpretation. Part 8. Ensuring access to justice for rights holders. Question 27. What are your views on the most effective ways of supporting advocacy and or advice services to help rights holders realise their rights under the bill? My response: I think advocacy services should be strengthened and made more accessible for all with regards to human rights, but not specifically for this bill, which I think is deeply flawed. And there's a second part to this question: legal aid. Access to legal aid is an important aspect in supporting rights holders to claim their rights through the courts, where they choose to. We remain committed to reforming the current system of legal aid to place the user at its centre. My views: the current system of legal aid certainly needs to be improved with urgency. Again, not specifically related to this bill under question. Question 28. What are your views on our proposals in relation to frontline complaints handling mechanisms of public bodies? And this is about the Scottish Public Services Ombudsman. So I'll just continue to this bit. Under this proposal, the Scottish Public Services Ombudsman would be able to issue declarations of non-compliance when a specified public authority is found to have acted incompatibly with these updated procedures. And this is quite a tricky area. I think there's a lot of potential harm in this. And I think this other bit is very important. The proposal is to further consider own initiative investigation powers for the Scottish Public Services Ombudsman. This could allow them to look into areas of concern where no complaint was made, or consider beyond an individual complaint where other individuals may be affected. My views: I think that the public services complaint handling procedure could be improved generally, but I would not want the duties in this bill to be automatically considered by the Scottish Public Services Ombudsman. I also do not like the idea of giving the Scottish Public Services Ombudsman own investigation powers. It would further bring into question the whole concept of human rights if a public body was to choose to investigate rights infringements, so-called, that no one had actually complained about. This would be strongly open to abuse. Question 29. What are your views in relation to our proposed changes to the Scottish Public Services Ombudsman's remit? I think the important bit in this is the last bit where it says the Scottish Public Services Ombudsman would be able to issue declarations of non-compliance when a specified public authority is found to have acted incompatibly with these updated procedures. My views: this proposal seems to imply that human rights and economic, social and cultural rights could be used as a form of coercion, maybe as a party political tool. It doesn't sit well with me. Question 30. What are your views on our proposals in relation to scrutiny bodies? Scrutiny bodies is a broad and overlapping term and can cover complaints handling bodies such as the Scottish Public Services Ombudsman, inspectorates, regulatory bodies such as the Care Inspectorate, HM Inspectorate of Prisons for Scotland and the Scottish Housing Regulator, but also other bodies which have an oversight role, such as the SHRC, which is the Scottish Human Rights Commission. My views: this proposal would build a network of scrutiny and control, not of what I would consider human rights, but often quite vague concepts, such as a healthy environment, sustainable food, and the right to health. Ideals which are generally desirable, but which are open to wide interpretation. As an example of where this could lead, in 2014, I was persuaded to have the loft in my flat insulated free of charge under a government environmental scheme. In 2020, 6 years later, there was a terrible outbreak of black mould in the flat. I was advised that the loft insulation, which may have been poorly carried out, the company that did the work is no longer in business, had reduced air circulation, leading to ideal conditions for the mould to grow. This doesn't mean that insulation is a bad idea in itself, but that well-meaning schemes can have unforeseen consequences, and they can also be linked to industry lobbying. which is why I believe that linking strong powers of coercion from authority bodies to vague ideals is a very bad idea. Question 31. What are your views on additional powers for the Scottish Human Rights Commission? The Scottish Human Rights Commission was established in 2008 and functions as Scotland's national human rights institution. It is an independent parliamentary commission and currently holds A status accreditation. We are exploring the potential for the Scottish Human Rights Commission to have new powers in the following areas, which would require the Human Rights Bill to amend the Scottish Commission for Human Rights Act 2006. In particular, we see value in extending the powers of the Scottish Human Rights Commission to include the following in support of bill implementation, oversight and accountability. Powers to bring or intervene in civil proceedings under the bill. An investigatory power which allows for accountability for systemic issues relating to the rights in the bill relating to civil matters. My views. I think this would be very wrong because so many values and ideals which are not human rights are being lumped in with human rights in this bill. Infringements on a healthy environment could mean almost anything and should not come under the remit of the Scottish Human Rights Commission. Question 32. What are your views on potentially mirroring these powers for the Children and Young People's Commissioner, Scotland, where needed? My views. I don't think the proposed rights in the bill are human rights, so I definitely don't think there should be additional powers for these bodies in relation to this bill. Question 33. What are your views on our proposed approach to standing under the Human Rights Bill? Standing refers to who has the legal right to raise an issue with the courts for judicial review. The current test for standing in relation to judicial review proceedings in the Court of Session is the sufficient interest test, except we're based on the Human Rights Act 1998. This test requires an individual to demonstrate a sufficient interest in the subject matter of the, in brackets, judicial review application. This means that individuals as well as organisations wishing to advance a widely shared interest may bring cases to court where they can demonstrate a sufficient interest. This is different to the narrower victim test under the Human Rights Act 1998, where a person must demonstrate in effect that they are directly affected by the breach they are alleging. This largely restricts organisations from bringing public interest litigation and is less open than the sufficient interest approach. The UN Covenant for the Rights of the Child Bill also provides new powers to both the Children and Young Persons Commissioner for Scotland and the Scottish Human Rights Commission to bring or intervene in legal proceedings. We want to mirror this approach to standing for civil proceedings brought under the Human Rights Bill, so that civil society organisations with a sufficient interest in a case will be able to bring proceedings if the courts deem it appropriate in a particular instance. Powers for the Scottish Human Rights Commission and potentially the Children's and Young Persons Commission Scotland to bring or intervene in civil cases under the bill would strengthen the ability of those bodies to support individuals and address systemic issues through the courts. This is a major change that they're proposing, and I think it's clear where it could lead. Organisations would be able to bring legislation through the courts under the Human Rights Act. Think about that. My response: I think this could lead to abuses whereby powerful interests could try to lobby organisations to bring action under this bill, which appears to be in favour of people, maybe people with protected characteristics, but could materially benefit them in some way. The vagueness of many of these rights categories make this a strong possibility, in my opinion. Question 34. What should the approach be to assessing reasonableness under the Human Rights Bill? My views. I don't know enough about the law to decide on the reasonableness issue, but I do think this bill, if implemented, could bring in dangerous new powers that could be open to abuse. Question 35. Do you agree or disagree that existing judicial remedies are sufficient in delivering effective remedy for rights holders? My response, agree. 36. If you do not agree that existing judicial remedies are sufficient in delivering effective remedy for rights holders, what additional remedies would help to do this? My response, not applicable. Question 37. What are your views on the most appropriate remedy in the event a court finds legislation is incompatible with the rights in the bill? My response, I don't agree that the proposals in the bill are actually rights, so this question is therefore irrelevant. These vaguely described open-ended rights could potentially have the effect of sneaking in all kinds of legislation through the back door in the name of human rights, if the proposals become law. Part 9. Implementation. Question 38. What are your views on our proposals for bringing the legislation into force? Bringing the Act into force. We will need to bring the bill into force in order for the duties outlined earlier to become legally binding upon those delivering devolved public functions. We intend to commence these duties in a sequenced fashion, one after the other, with periods of time in between. My views. I don't think this bill should be brought into force at all, never mind quickly. The word force says it all, really. In my opinion, it is a coercive lever that could potentially have very negative effects for many people, not something that would be positive for people. The information panel says, the Lived Experience Board stressed the importance of moving forward with implementation quickly, given the increasingly challenging environment around the cost of living and inequality. Why do we need a replacement Human Rights Act in order to achieve this? I can think of many ways to improve the cost of living. Less involvement in overseas wars and stronger measures to stop corruption and crony capitalism would help. And we already have legislation in place to fight inequality. More education about how this should work would surely be more effective than just putting more coercive tools in place. Question 39. What are your views on our proposals to establish minimum core obligations through a participatory process? Part 7 of this consultation covers duties and sets out our proposals for a duty to comply. My views. Minimum core obligations should have no place in a human rights bill. How would minimum core obligations protect the right to life or the right to religious freedom? Could someone only partially be killed or only partially be persecuted for their religious beliefs? Duty to comply is the revealing statement here. Human rights are about holding power to account, but this bill would effectively give authority more power. Many of the people who worked on this bill and SNAP 2 probably had well-meaning intentions, but maybe some of them were naive because it comes across as a manipulative and quite dangerous sleight of hand. Question 40. What are your views on our proposals for a human rights scheme? Human rights scheme. As set out earlier, we want to include a duty on the face of the bill for Scottish ministers to publish a human rights scheme. My views. I don't agree with the proposals to introduce this bill, and I don't think that giving people more information about it would improve things. Question 41. What are your views on enhancing the assessment and scrutiny of legislation introduced to the Scottish Parliament in relation to the rights in the Human Rights Bill? Parliamentary scrutiny. We want to ensure that legislation introduced to the Scottish Parliament is assessed against its compliance with the rights contained in the Human Rights. My views. The purpose of human rights is to hold power to account. And on this basis, it's understood that new legislation should be compatible with core human rights. So any new legislation about working practices, for example, would have to comply with religious freedom and equality rights. This proposed bill veers away from core human rights. so it would be quite wrong for other legislation to be assessed against compliance with it, as it could lead to terrible abuses and possibly corruption. For example, big multinational corporates with the financial clout to lobby could use this bill to claim that small local businesses have to adhere to sustainable trading practices that could effectively put them out of business. Question 42. How can the Scottish Government and partners effectively build capacity across the public sector to ensure the rights in the bill are delivered? My views. I do not think the so-called rights in the bill should be delivered by means of enforcement as proposed. They may be ideals to work towards, but they definitely should not be enforced or complied with. I feel very uncomfortable with the frequent comparisons made to the UN Convention on the Rights of the Child and equality standards. It appears that the bill is being tagged to these emotive issues in an attempt to frame it as something that would protect the weak, when in reality it could have the opposite effect and could further entrench power and control. Question 43. How can the Scottish Government and partners provide effective information and raise awareness of the rights for rights holders? Information and awareness raising for stakeholders. Having available, accessible information on the rights in the bill and human rights more generally is absolutely vital in order to allow rights holders to claim them. Working with stakeholders, we will develop plans for information and awareness raising, including a campaign that is aligned with future timescales for implementation. My views. The proposals as presented in this consultation appear to me to be quite manipulative, appealing to people's sense of justice around equality and protecting the weak and the environment in order to bring forward potentially draconian controls over the food we eat and how we live our lives. Controls that could be enforced through a network of authorities that would themselves be subject to compliance enforcements. I therefore would not trust any information or awareness campaigns associated with it. And finally, question 44. What are your views on monitoring and reporting? Monitoring and reporting are key to realising the rights in the bill, and we view this as a need to assess both previous action and future plans. Our developing approach to monitoring and reporting is reflected elsewhere in this consultation, particularly in relation to the proposed reporting duty for certain public authorities and the human rights scheme. We have considered whether or not to establish a national mechanism and are of the view that the Scottish Government already carries out the core functions identified in the UN guidance, which notes that a ministerial model is one example of good practice. We want to strengthen our approach in this area and will take forward work to consider how best to do so. Once again, jargonistic terms that sound very simple and would be easy to skim over, but they actually carry quite a bit of importance, like national mechanism and a ministerial model. So I had to look up national mechanisms to find out what exactly it meant. My views. National mechanisms appear to be standard approaches for nations to handle violations of equality rights or freedom, modern slavery. These are very emotive issues, and it seems important to have these agreed mechanisms in place to protect those rights. However, in the context of this proposed bill, with its vague, open-ended ideals being presented as human rights, using national mechanisms in this way could reframe the existing structure into one that could pave the way for creeping totalitarianism. Or if that sounds extreme, it could certainly enhance crony capitalism. It's quite an exhausting task going through this consultation, just reading the questions, never mind answering them all. So it's not really surprising that many people might just give up on it altogether, or maybe skip questions, or just go for the easy read version instead. So let's have a look at how the easy read version presents all this very important information that could dramatically change all of our lives. you.